So there's a lot of excitement about a case for appeal that's been filed at the Supreme Court. And this is Harper versus Falconer, who is actually the commissioner of the IRS. He's no longer the commissioner as of today. So Harper versus Commissioner is an interesting case because they're claiming that his rights under the Fourth Amendment of the Constitution have been violated by the IRS. What happened was the IRS, using a John Doe summons, collected roughly 14,000 names from Coinbase back in 2018, 2019, that time period. And from there, they issued letters to people threatening them with an investigation. And in this case, Mr. Harper received a IRS Letter 6174A, which is the same letter that's being issued today to tens of thousands of crypto users. So this is very significant, very relevant. Now, this letter 6174A does not actually say that an audit has begun. It simply warns that we know that you had accounts and you may not have reported everything correctly. Please double check. That's what it says. So what Harper is saying is that his information from Coinbase has been a violation of his rights. The Fourth Amendment of the Constitution protects a citizen from baseless warrants and searches of his property, that if a search is to be conducted, that there has to be reasonable cause, there has to be a basis for the search being authorized, etc. But a John Doe summons is a summons where we don't know the person's name, but we're asking for information about them. Now, this has been used in the past, what's called the third-party doctrine, where you're going after a third party for information about the person that you're really interested in. In this case, the third party is Coinbase. And you're going after them because you believe these people have engaged in a particular crime. But here, they were not going after people engaged in a particular crime. They were going after people that met certain qualifications of having a certain account open at a certain time, of which it was not against the law to have those accounts. So it was a baseless search. There was no real probable cause to justify the use of a summons. And now this letter is being issued on that same basis. On that same basis today, these letters are being issued solely because they acquired data from Binance. And this is a very hot topic. Have you gotten one of these letters? You want to listen up. Now, the argument is that this is an unlawful use of the third-party doctrine and cannot be justified. It's a baseless search, and that the IRS must stop using this method, and they must drop any investigation they have of the taxpayer. And this happened back in August of 2019. So think about that. It's been 6 years since this happened, and it's now hitting the Supreme Court. But what a timely occurrence, because these letters are now being issued again. Starting in December of 2024, they're issuing about 10,000 letters a month to people, trying to scare them into disclosing information about their crypto trading, possibly in years that they no longer are able to amend or report. So very interesting. I think it has a bit of misleadingness to the letter, and I think the IRS has some real explaining to do. What do you think? Should the IRS retain this right and privilege, or should the IRS limit the use of third-party summonses in the interpretation of the Fourth Amendment of the Constitution? Very interested in your thoughts. Please put it in the comments below, and please like, subscribe, and follow. It means a lot to us.